Hello, beautiful people. As always, welcome back. I think it's about time that I introduce you to a life-changing information. If you know this, you would be ahead of the crowd. And what is it? The thing that causes a lot of people to say, I will sue you. See, threatening someone you're going to sue them is really not the core of suing. Knowing how to take that which belongs to a tortfeasor is the core of suing. The question most people ought to ask themselves is, do I know how to take from the people who are taken from me? Before I utter the phrase, I will sue you, or before I even think about suing someone. 3 specific videos have been done to kind of prep you for this specific video. The first one was introduction to garnishment. The second one was introduction to how you can use the United States Marshal for the purpose of garnishment. The third one is explaining the importance of maritime lien and private contracts as it relates to garnishment. But see, all those things are really the end game. All those forms shown in those videos and what's expected. That's in summary what this first item, letter A, tells you. B, specific kinds of remedy. Remember, all laws are specific, right? And there's specific kinds. Isn't this what everyone is looking for? Remedies. The remedies available under this rule includes the following. However designated and regardless of whether state procedure requires an independent action, regardless of whether there are any other legislative language at the state level that says, hey, you have to do something that might be different. These things are generally applicable, and that is arrests. Yes, arrest of someone can come out of a civil action. Attachment, meaning you attach the judgment against their land, their house, their vehicle, their paychecks, their bank account, their lock boxes. And in some cases, like they do to you with taxes. Replevin is the process of taking back something that once belonged to you. Meaning your remedy when it comes to seizure or the taking of property can be, you know what? I don't want to do anything else. I just want this guy to give me back my house. I just want this guy to give me back my vehicle. I just want them to give me back my monies. I just want them to give me back something they once took from me, aka property. Real or personal? Real dealing with land, personal dealing with anything else that you are related to that you can identify as your property. Persons being arrests. Yes, an arrest can arise out of a civil action. You heard that right. But listen to this extremely important part as it relates to the use and enforcement of an injunction and other corresponding or equivalent remedies. Do you know what these other corresponding or equivalent remedies are? That's right. That injunction of yours, whether it be afforded by law, not at law, but by law, for the enforcement of a judgment, which is not an action, but is included in the phrase process in an action. Meaning a writ of execution is a type of writ that comes to life after it has been reasonably determined that you are right and that you have the standing and capacity to take from someone. The signing of an instrument, signing, coupled with sealing, acknowledgement, and attestation, as such may be required by statute, and the delivery of the instrument. The signing and delivery of a negotiable instrument, the performance of a duty, assignment, or obligation. So now once the writ has been issued, who do you administrative process that people send 3 times? Sequestration, an equitable writ or process, and the remedy thereunder. Under, meaning under the process. What process? The process of them abrogating you and you showing by preponderance of evidence that they've done so. An equitable writ or process, and the remedy thereunder by which property is taken into the possession, seizing a property. Sequestration. An equitable writ by which property is taken into the possession of the court in order to assure obedience to a decree. Meaning when something is done, you know, they say 90% of all court cases won are never collected. The reason why that is because most people who win a judgment, or most attorneys who assist their clients win a judgment, do not do a writ of execution or any of the listed writs that was in the previous items that we've just read. An arrest, sequestration, Replevin, execution, or other types of relief. Why? Because usually the opponent also has an attorney, and privately the attorney of that opponent and the attorney that you hired to assist you get that judgment have decided, you know what, we're going to look out for one another, and I'm not going to look like I lost and fail my client. So even if you get this judgment, make sure you don't follow up on it properly. That is the reason why 90% of judgments won are never collected. It's not like it's hard. It's not difficult to do. In fact, the moment you have that order, you have that other party's world in the palm of your hands. And you can do a lot with it. Most people who say they have rights, one, don't even get to the stage of settlement, let alone even get a judgment, let alone even know what to do with it. Interest, whose interest appears on of record any obtained discovery from any person. In other words, your trust can be a successor and a sign of that judgment, because it would always be the first lien holder of that ins ligas and the spiritual name. Do you see what's going on? Do you see why it's important to know all the basics of how trust and all these things about trust that I've been speaking of months after months, and its varying details and varying degrees? We're going over these things in these increments because those are the important things that you need to know to enforce anything. These words that they put on their pen and paper, black and white, they mention it in one or two words and move on. If you don't know what they're referring to, it is your problem. They don't care. They're going to say and think, well, we wrote it on a piece of paper for you. Your lack of knowledge of what you're reading is your issue, not ours. You don't want to fall under that category. You know better, so you do better. So when you read this, you know this is referring to your trust, to which no one can now come and start meddling with the interest to say, well, I want to do an appeal. Do you know one of the reasons why you actually created trust is so that if and when? In the second video regarding the power of subpoena, we made it very clear towards the middle and the end that you can use subpoena to go after. The complete 26-minute video, the first part of this video series, is uploaded on January 28th on the Patreon page. Take care. Best of luck.